Next case on the docket is Secured Capital Trust versus Green Planet Servicing. Wherever you're ready. Is 5 minutes okay?
Yes, I'd love to reserve that. Thank
Okay.
you. I have a booming voice. I hope I don't overpower everyone here. If it please the court, Your Honors, thank you for the time. I am Gregory Mauser. I represent Secured Capital, who is the appellant in this matter. This case is actually a case of first impression, at least I believe so. It has to do with the interplay between a bankruptcy and a state proceeding. And recently this court, the 5th DCA, has issued an opinion that's consistent with the surrender doctrine. And because there's new case law, I cited some additional authority before coming here, which actually crystallizes the issue a little better than I think the briefs do. So I'd just like to address that. The real issue on appeal is whether a bankruptcy trustee can assign and sell defenses to a mortgage foreclosure action. And the two cases that have recently come out are the case that most recently came out was about a month ago. It's in Ray Failer. It's an 11th Circuit case, and it discusses the surrender issue. Another case that I cited as supplemental authority is the In Ray Larkin case. And I'd just like to start with that. And the In Ray Larkin case directly deals with, it dealt with a borrower who was involved in a foreclosure action a borrower who was involved in a foreclosure action who filed bankruptcy. And in the bankruptcy, the borrower exempted the subject property. And by exempting the subject property, they also had a counterclaim in that. The counterclaim was clearly part of the bankruptcy estate. The trustee sold the counterclaim and also, as part and parcel of it, got rid of a portion of the defenses. The Southern District of Florida in Larkin said the trustee can't do that. If there is an exemption of the subject property, that means there's a retention of those rights, and the trustee can only make use of those defenses for purposes of the bankruptcy, but cannot dispose of, limit, or otherwise destroy those defenses. That was the Larkin case. Most recently, just a month ago, the 11th Circuit said, but where there is a surrender, where there is a surrender of the rights, the borrower no longer retains any rights, not even the right to defend. And again, the 5th DCA issued an opinion similar to that. It was on an appellate case where there was that about 6 months ago. But the key language in this is, and I'm sorry, in that case, and I apologize, in that case, there was a surrender and the trustee abandoned the property. And the argument was, well, look, if they abandon the property, then after the trustee disposes of it, it goes back to the secured creditor because there was a surrender. Here's what they said, though. If there is not a surrender, it says debtor who files a statement of intent to surrender the property that collateralizes secured debt performs in accordance with stated intent by first surrendering the property to the trustee, who decides whether to liquidate it or to abandon it. And if the trustee abandons it, then debtor performs by surrendering property to the creditor. What that means is the trustee can sell defenses. At least that's how I interpret that. And that's what this case is about. And now I'll just touch on the factual issues that were before the court. The borrowers in this case were the Mankowskis. Before a foreclosure action was filed, they filed for bankruptcy. They did not exempt their property and therefore surrendered it. The trustee took that property and sold the property along with an assignment of all defenses to a party who ultimately sold it to my client. And since the subsequent assignment, they can't assign any more than they have, it's in part, for the rest of this, I'm just going to refer to it as my client obtained it from the trustee because it can't obtain more rights and certainly didn't obtain less. The foreclosure action was filed and my client was named. In the naming of my client, plaintiff alleged that all conditions preceding had occurred. Not that they were waived, not that they were destroyed, not that they were surrendered and that plaintiff was the holder of it. They just said all of them had occurred and specifically referenced in their complaint a letter in accord with paragraph 21. This mortgage is a little different. It's missing an early paragraph. So what it would be a normal paragraph 22 is 21, would normally be a 20 is 19, and I'm going to reference paragraph 18, which is paragraph 17 in this. So there's a little confusion, but it's just that an earlier paragraph is missing. Anyway, my client denied those allegations, saying that the conditions preceding had occurred, and asserted an affirmative defense, saying you didn't do this right. And what the real issue is, and just so the court knows it, is in the bankruptcy, the borrowers filed a notice of change of address. Now, they told everybody by written document that they were no longer at the property address. And when the paragraph 22 letter was, or paragraph 21 letter in this case was sent, it was sent to the property address, not to the new address. So at a minimum, a dispute of fact exists as to whether proper notice was even sent, because pursuant to paragraph 15, which in this case is paragraph 14, it's sent to the property address, or if a different address is specified, then it has to be sent to that address. It wasn't sent to that address, and the question is whether a notice in bankruptcy constitutes a proper change of address. There's at least a dispute of fact. Anyway, in the trial court struck our affirmative defense, and we believe did not hold the plaintiff to the burden at a summary judgment hearing that they had to prove a condition preceding. We're not saying we had the right, in fact, we're not saying we had the right to redeem, but they pled it based on the paragraph 21 letter that they sent, that the default was one that could be redeemed. And what is never discussed, and the reason I cited Bartram, which came out last week, and the subsequent authority, is it's the first time anybody's ever mentioned, hey, we got a due on sale clause that if somebody violates, if somebody sells or allows to be transferred the security, securing the debt, well then that constitutes a non-curable breach, and there's a procedure for that. The procedure for that is to send a letter, and that's outlined in paragraph 17, paragraph 18 of the normal.
I'm
yes,
sorry,
sir.
as the owner of the property, you
Yes.
could reinstate. You couldn't, I'm sorry, you could redeem, you couldn't reinstate.
Correct.
I thought you said you couldn't redeem.
I'm sorry, no, we can redeem. We have the right of redemption.
You can't reinstate.
We can't reinstate. And I apologize if I misstated that. There are two types of defaults that are in every mortgage contract. One is a default you can cure, and the other is a default you can't cure. Bless you.
Thank you.
And if they predicate their complaint against the borrower and against my client on a default you can cure, in a bankruptcy situation that doesn't make any sense because nobody can cure. The debt itself has been extinguished and is only redeemable against the property by way of the secured property. That's the only entity that's responsible for the debt at this point. My point is, they could have avoided the whole problem by pleading this correctly and saying there was a transfer in the security, by sending a letter in conformity with it and saying, hey, look, we accelerate the debt pursuant to the terms. But whether it's a curable debt or a non-curable debt, you have to send a letter.
To whom?
And to the borrower. And if they sent a letter to anyone, whether my client or to the borrower, I would deem that sufficient. I wouldn't be before the court, but you can't send it to the borrower at the wrong address. And that's why I think, at a minimum, this case should not have been granted a summary judgment, but we should have been permitted to argue that. We were not permitted to argue that point. Yes, sir.
If that is a condition precedent, the sending of the, in this case, paragraph 21 letter,
Yes, sir.
and they sent it to the wrong address,
Yes, sir.
they still, it was directed or addressed by name anyway to the correct person, that is the original borrower, the Mankowskis.
Mhm.
The Mankowskis aren't going to redeem,
No, sir.
so in that situation, sending the letter, whether they send it to the correct address or the incorrect address, is truly a futile act, isn't it?
Arguably, no. And I'll get to it, and it's a technical reason why it's not. I will say it is a technical reason why it's not, and that's a very good point. But the mortgage itself says, unless you send this letter pursuant to this, you don't get to file suit. It states it's a condition preceding the sending of this letter to the address of these people. And it's whether it's a curable or non-curable, you still have to send the letter at a minimum as a condition to acceleration. Paragraph 20 in the normal mortgage says you can't bring, in the normal 19 in this one says, you can't bring an action against anybody. It doesn't say against whom, but it says you can't bring an action or you can't be named in an action unless this has been done. Some letter notifying of the default. And it says specifically whether it's paragraph 22 or 18, or in this case, 21 or 17. It specifically says that. Then, in paragraph 17 and paragraph 21 of this, it says, if you want to accelerate, here's what you have to do. So there is a second hair split here. First one is, I think we're entitled to the defense, condition preceding. I think that's what takes this out of the Clay County analysis. Because in the Clay County analysis, it says, the only one who has the right is the borrower to assert his defense. Well, the borrower doesn't have that right anymore because of the surrender and bankruptcy. The trustee would have it, so in this case, if there's a trustee, that Clay County case is just wrong because the trustee has the right to assert it. And the question again comes back to full circle, does the trustee have the right to sell it? If the trustee sold it, and the Fela case would indicate, yes, they do. They can liquidate or abandon. But it doesn't say it just disappears and goes away and nobody gets to use it. So with that said, there's this second issue. And the second issue is this. And again, my client, as an investor who somebody purchases this to rehab them, do everything else, there's the acceleration issue. And even if you say, well, Clay County is still applicable in this, even though I don't believe it is, the second holding and third holding and fourth holding of Clay County is that, hey, but a subsequent purchaser gets a right to argue damages. Acceleration is a damages issue. So even if you say my client does not have a right to assert the contractual defense of condition preceding, there is still the damages issue as to whether they properly accelerated or not. And there's a 5th DC case I've cited for that proposition, which I believe is the Parisi case, which clearly states, hey, when you have to do something to accelerate, you have to do something to accelerate. And if you don't do that, your debt is not accelerated. So I'm asking the court to either remand this so that we can at least argue the issue, say we have the defense and can argue the issue, or reverse it and say, hey, look, you need to do damages. We were denied the opportunity on that. You didn't properly accelerate, so the damages entered should just be for breaches that occurred prior to the filing and not for future breaches, not accelerating the debt. Those are things I'm asking the court for, and I think I'm a little early unless there's a question for me at this time.
Nope, no questions.
Thank
Thanks.
Mr. Massaro. May it please the court. My name is Barbara Egan, and I represent the appellee in this case, Planet Home Lending, formerly known as Green Planet. To us, the point before this court in every issue raised by the appellant is founded on one premise that is flawed. The premise is that Secured Capital, who was a stranger to the mortgage, who took the property as a stranger to the mortgage, is entitled to rely upon contractual defenses that would have been available to the original borrower in the contract, the mortgage, between the borrower, I can't say that word, borrower and the lender. The bankruptcy trustee was not a party to that mortgage. What was transferred into the bankruptcy estate was the property, subject to liens and encumbrances. So those contractual rights of the borrower to contest insufficient notice and the other things they've stated in their brief were their rights. Yes, the bankruptcy trustee can assign, as they did, personal defenses of the borrower, but those are different. Those personal defenses are those types of defenses that arise in law, usury, statute of limitations, those types of things, and we kind of go through them in our brief. And I think the case, Clay Capital, lays this out, and they're correct. There's just no standing on the part of a party who's a stranger to the contract to raise these notices, to raise these defects in notice. And so it does not create a dispute of material fact. It's immaterial under the context of this case. And what we need to remember is my client sued the original borrowers, the Mankowskis, along with the Homeowners Association and Secured Capital, because all had a potential interest in the property. Secured Capital was completely on notice that we were suing for the full amount of the debt. That was alleged in paragraph 12. There's no prejudice to Secured Capital. It was served with the lawsuit. It answered the lawsuit. But it could not come in and say, I represent the borrower. I can defend as the borrower would defend. Secured Capital has no legal foundation to argue that it stands in the shoes of the borrower for purposes of the mortgage contract. And I think this is where it all falls apart. And the arguments sound plausible, and they sound like they have some substance to them, but they're just wrong. And I think the trial court got it right. And what we are asking this court to do is to affirm the trial court, affirm the final summary judgment, and send it back with that. If there's no further questions, I really have nothing more to say.
Okay, thank you.
Thank you, Your Honor.
You have a little over 5 minutes.
Just to address the points that were raised is to say we just got it wrong, and I don't think we did. I think there's clearly a case out there. It's the 11th Circuit, and they say, hey, this is how it works. And if the trustee has the benefit of all defenses, it's clear, it's in the federal statutes, it's cited by appellee in their brief, and it says they have the benefit of all defenses. The question is, can they sell it? And the real issue is, who gets to decide that? Is that an issue that perhaps should have been brought in the bankruptcy court? And if brought in the bankruptcy court, because in the bankruptcy court, when there's a sale the other side gets notice, and they get an opportunity to object, and if the objection was, hey, look, these guys don't get the defenses, that certainly could have been molded into it. But the transfer, the recorded deed that my client, the predecessor of my client, and then my client received, says you have the benefit of all defenses. It was sold. And the question is, who gets to decide that? And I don't think the trial court gets to decide that. I think that's at least a federal issue. Maybe you all get to decide it, but it's an issue that is important. It's not made up. We have a clear, this is what happens when somebody surrenders. We have a clear, this is what happens when somebody doesn't surrender. But what we don't have is when somebody surrenders and the trustee sells that right, we don't have a clear case out there that I'm aware of, or apparently that the appellee is aware of, that says, no, you can't sell this.
Let me ask you this
Yes, sir.
from a slightly different angle. You agree that the paragraph 21 or the paragraph 22 letter is a condition precedent, correct? To acceleration.
Yes, and let me qualify that with either that one, or I believe the more appropriate in this would have been the letter pursuant to paragraph 17. I don't think giving the borrower an opportunity to cure when they can't, or serving, or saying, hey, look, you have an opportunity to cure when they can't, or enforcing that against my client when they can't, I don't think that is the right one, but that's a factual issue that I think should have been decided on summary judgment.
But regardless of which paragraph, you're saying that either one of those are conditions precedent.
Yes, sir, I am.
All right. Well, and we talked about this a little bit in the last oral argument. There is a difference between conditions precedent, which if the defendant denies, the plaintiff then has to prove.
Yes, sir.
And a defense, an affirmative defense. So if sending the paragraph 17 or paragraph 21 letter is a condition precedent either to acceleration or foreclosure, how can you then say, well, no, it's not a condition precedent in this context, it's really an affirmative defense that the trustee has the right to sell?
Oh, I'm not. When they made the allegations within their complaint, those were denied. And because they were put in issue, we believe it's an issue that plaintiff had to prove, and did not, to a summary judgment standard, prove it. We also asserted as an affirmative defense. And it was the affirmative defense that was stricken. But in striking the affirmative defense, it seems that we lost the ability to challenge it as an element of the prima facie case, which is another reason why we think it should be reversed, if for none other. If I answered that, I'd just like to cover two more points very quickly. They said they sued the borrower because they have a potential interest. According to FALA, no, they didn't. They didn't have anything they could assert. They should have been named in name only because they have no further interest. It was surrendered in the bankruptcy. And again, I believe the issue is who decides if the trustee can or cannot sell it. I believe the mortgage itself says, well, if there's a contract, if there's a conflict between the terms of this mortgage, which there might be, and I think it's noted in there that I believe the trial court found the word assumable to equal the word assignment, which they aren't. Pursuant to paragraph P of the mortgage itself, it says you can be a successor in interest by obtaining an assignment of the right, but not assume the note. There's a paragraph in there that specifically addresses it. But I think the judge got that one wrong, and for no other reason, you should go back for that. But the issue is whether the trustee can sell it and who gets to decide whether the trustee can sell it. And I'm got like 19 seconds left, so if there's a question, I'd love to answer it. If there's not, I thank you very much for your time and attention.
Thank you.